Good day and welcome to another exciting edition of the Front Desk. It's almost the end of the year and we've already had an exciting year for BRPs. A number of them have said that there is a lot of space for regulatory reform within the business rescue, business restructuring and liquidation sector. To discuss this, joining me today are two very accomplished legal minds, Lucinde Rhoodie, who is a director at CDH, and Muwanwa Ramanyimi, who is a senior associate at CDH. And they're going to be discussing some of the space for this legal regulatory reform and where we're going to go from here. So Lucinde, I think let's start with you. Calls for regulatory reform in business rescue, turnaround and insolvency are not new. Do you feel that these calls are justified? And can you provide some examples to just back that point up, please?
Yeah, good afternoon, Jonathan. You know, the business rescue space is a very dynamic one, which from the inception of Chapter 6 of the Companies Act have really kept our courts very busy. And courts have been and called upon to interpret the provisions of the Companies Act when it comes to business rescue regularly, and they must do so against an ever-changing business rescue industry. And I specifically call it an industry because that is exactly what it has become, an industry, not only for business rescue practitioners and in that space, but, you know, also in your private equity funding space, post-commencement finance space. And when it comes to calls for reform, we need to keep the purpose and objective of business rescue in mind, being, of course, to facilitate the return, if possible, of a business in financial distress to financial health. So one of the most current and I think hottest topic when it comes to calls for reform relates to the definition of creditor under the Companies Act, Chapter 6, specifically whether a post-commencement financier should have voting rights in respect of a business rescue plan. Muwanwa will discuss this in more detail, and I'm certainly not at this stage going to venture an opinion on the correctness or not of the Westcol judgment, which she is going to speak about. But what the Westcol judgment did bring to the fore is this division in the industry on the status of PCF creditors when it comes to voting on business rescue plans, and in particular, whether the judgment will actually cause the appetite for providing PCF to decline. So yes, there is definitely reasonable request for reform, which must be given attention to.
I think from my point of view, and I'm just engaging with the BRPs, I don't think they have an exception to the actual ranking of PCF, PCF financiers in it. But I think the question from their end is, should they be treated as preferential creditors, or should they be given the same rights as preferential creditors or not? And that's where sort of the sticking point is with regards to some say yes, some say no. But Muwanwa, let's move on to you and let's go into and unpack that decision. The decision in 2023 ruffled a few feathers in the industry, with some experts saying that the decision was setting a dangerous precedent. Obviously, that has been challenged at the Supreme Court of Appeal. What was it about that original decision that was put down in October? What was it about it that was that caused such an outcry? Sorry, Muwanwa, I think you're on mute.
Thank you for the question, Jonathan. I was on mute. Just to maybe remind everyone what the Westcol judgment was about, the crux of that dispute was in respect to the definition of creditor in Chapter 6 of the Companies Act. As we all know, creditors have the right to vote for the adoption of a business rescue plan in business rescue proceedings. In Westcol, the court embarked in an interpretative exercise to determine whether creditors' voting interest extended to both pre- and post-commencement creditors. The applicants in that case were of the view that PCF creditors are not creditors with voting interests, in that they cannot vote for the approval or rejection of a business rescue plan, which essentially meant that only pre-commencement creditors would have voting interests. The High Court agreed with that contention and ordered that only pre-commencement creditors had voting interests. The outcome definitely ruffled a few feathers because it could have far-reaching consequences in the landscape of business rescue, particularly in respect to ailing businesses' ability to attract and secure post-commencement financing. PCF is very crucial for a company in business rescue, and as such, as a result of that judgment, post-commencement finances would have, if they have no voting rights, that would make the proposition for them to fund a company in business rescue less attractive. And without PCF, unfortunately, some businesses will be forced to close their doors permanently. And this may lead to a magnitude of failed business rescue proceedings, which will essentially defeat the purpose of the procedure as a whole.
Yeah, and I think that goes to something that I've spoken about in the past before, whether we are in a business rescue sort of environment or if we are favoring a liquidation environment. And I think if you are saying what you're saying and PCF funding, post-PCF funding or pre-PCF funding becomes scarce, we're then moving dangerously towards a liquidation-based society, which is not where we want to be. So what view should the court have taken in the original decision then, Muwanwa, to avoid some of this outcry?
Yeah, the Westcol judgment has been taken on appeal, and it will be interesting to see what the appeal court's view is on the issue. What was interesting, though, in the court's finding, the High Court's finding, was when it was making the decision that post-commencement creditors do not have voting rights. And I quote here, the court actually said that there would be little to stop speculators or asset strippers preying on business rescue proceedings, blocking the adoption of appropriate business rescue plans, and forcing liquidations where they could be avoided, and close quote on that. So there would certainly be a risk in an instance where PCF creditors also has security in the company's assets, as they would then be, if they can vote in the business rescue plan and they finance the company and then they get security over the finance that they're giving to the business, then that would essentially mean that the PCF creditor will then be promoted from its ranking of being a preferential creditor, as they're given in the Act, to then becoming a secured creditor. And in that instance, in an instance of liquidation, if the company ends up going into liquidation, that would mean that the PCF creditor would essentially recover all of its debt and leave very little for the rest of the creditors. I will leave it to the powers that be, in this instance, the appeal court, to balance all these interests and all these considerations. I would like to note, however, an issue that I think that the High Court should have canvassed a little bit more in the Westcol judgment, because the creditor in that particular instance, even though they were classified as a PCF creditor, it was noted that some of its claims, it obtained them by virtue of cessions from other creditors. But it is not clear whether the cessions were in respect of creditors who were pre-commencement creditors. And if that was indeed the case, then at least that creditor should have been given some voting rights in respect of the cessions from pre-commencement creditors. I feel like that factor or that issue was not canvassed in detail, and it just left a bit of questions in that regard. So I hope that the Supreme Court does deal with that, but we'll see.
You brought up some very interesting points there. I mean, Lucinde, you've obviously been in the industry a little bit longer. From your, bear in mind what you've experienced in the past, how do you view the Westcol judgments, or the judgment that was handed down last year?
Yeah, I think in my view, if one analyzes the reasoning, I think it was a well-reasoned judgment. And I think it is correct, having regard to the correct interpretation and the purpose of interpretation of the Act. I think one thing that we must never lose sight of is, I understand the first knee-jerk reaction is that it is going to discourage PCF financiers to provide PCF, which, as Muwanwa correctly says, is vital in the business rescue space. But remember, PCF financiers stand in a very, very strong position. Not only are they coming in at a stage where a company is in a very precarious position? So a PCF financier can negotiate a PCF agreement with very, very favorable terms. The PCF financier has the right to insist on security being provided. It has a preferential ranking in claims in business rescue, whether or not it is secured or not. So we must just keep that in mind. And what does the poor pre-commencement creditors have, especially unsecured? They've got one power in the business rescue process, and that's a voting right on the business rescue plan. And to dilute that by giving PCF creditors voting rights, I think may skew the business rescue process and make it open for abuse, as Muwanwa has mentioned.
Okay. Moving on, I mean, obviously a lot of people have said sometimes the business rescue, restructuring and liquidation can be a little bit like the Wild West. You get the good, the bad, and the ugly. So from the Westcol judgment, we're now moving on to the judgments of Westcol 2 versus Anheuser-Busch InBev Africa, where although the court ruled in favor of liquidators and put the company in liquidation, they said this must not undo the good work that happened in business rescue. And that was the caveat that they gave. And this was very much praised within the circles. What was the court referring to when they made that caveat?
Yeah, so one must look at it in the context specifically of this judgment. This judgment entailed a scenario where there was no reasonable prospect of rescuing the business. At the time when this matter went to court, the assets have already been sold, the employees have already been retrenched, and the business as a going concern has already been sold. So company went into business rescue. The business rescue practitioners and the court realized and acknowledged that they were faced with the second scenario in business rescue, and that is where there's no reasonable prospect of saving the company. Business rescue and the plan is going to be implemented to secure a larger dividend to creditors than what would be in the event of a liquidation. So what the court had to look at here was to compare a liquidation scenario with a business rescue scenario. And the major creditors here, I don't think it's necessary for us to go into the details as to what the court looked at on whether the vote was inappropriate or not inappropriate. But I think what the court got right here is to say that when they make these type of decisions, especially in circumstances where we were dealing with the second leg of business rescue, i.e. dividends, which process is going to give you more dividend? You mustn't undo the good work that has been done by business rescue practitioners, because remember, and I think it's just a fact, a liquidation is a value-destroying process. When it comes to sale of assets, sale of business, it is fire sale values, and people out there are there to snatch a bargain. Where in a business rescue scenario, your business rescue practitioners can unlock more value for creditors. And I think that's the point that the court tried to make, is when they are faced with this scenario and they, for instance, set aside a business rescue plan and place the company in liquidation, what is going to happen to all the good work that has already been done? What is going to happen to that sale of assets? Must that now be set aside? What is going to happen to the sale of business? That's now open for attack. And then what is going to happen then is a liquidator is going to be placed in a position where it has lost immense value towards the assets. And I think that was the point that the court tried to make here, is that if one gets to this scenario, one must make sure that the good work that has been done in business rescue up to that stage is not flushed away by liquidating. But again, I think the principle is sound, but it was very, very applicable to the scenario that the court had to deal with, being not whether the company could be rescued, but whether business rescue would secure a larger dividend for creditors than a liquidation scenario.
Thank you very much. Muwanwa, I asked Lucinde this earlier, and perhaps I would like to hear your thoughts. From your side and working with BRPs, what reform would be welcomed by BRPs and turnaround professionals from in your point of view, and how easily would this be achieved within the profession, industry, environment that we're working in?
One, I think there needs to be a crystallization of what is meant by the word creditor. I think that's what everyone is just waiting on right now to see what the appeal court comes back with on that, in that regard. And then two, there needs to be some form of a regulatory body, because right now, yes, SIPS is there, but I think there needs to be a regulatory body which oversees the whole process of business rescue, because right now it's, when a business rescue practitioner, they're not doing their job, it's very, very difficult to get them, removed in that position. The process is so cumbersome. So maybe if there's a regulatory body that deals with complaints relating to business rescue and just oversees that the whole process is compliant with the act, that would, I think, in my view, that would be a good reform to come through. I don't know whether that will be very welcomed by business rescue practitioners, just because maybe they might prefer that the process remains the same, at least in respect of their removal process and everything like that. But I do think that it might be welcomed by other affected parties, particularly maybe employees who are often left powerless in the process. At least they might have a body that they might feel like it's looking out for them and things like that. So that is something that we look forward to. But the wheels of justice turn very slowly. So how achievable that is and things like that, it's just day by day and see how it goes. And as I said, I'm looking forward to the appeal judgment from Westcol, because whichever way that judgment goes, it will certainly be monumental in the business rescue landscape.
Just touching on the regulatory body, I mean, if we look at it, there obviously would be resistance from some parties. But if we remember when there was the establishment of the FSB, there was a lot of resistance when there was the establishment of the FSB, which has now turned into the FSCA. But as we have seen, the FSCA and the FSB took a lot of pressure off the courts and have done a lot of good for the industry, sort of holding everybody in check, putting the checks and balances in that the industry needs. So I think that would actually be a very good welcome to the industry. Lucinde and Muwanwa, thank you very much for joining us, and I hope to join you guys again when we talk about tax very soon, which is also something very interesting within our space.